All rise. Court of Appeal in the 46th District of the Florida Town Second. The Honorable Dan Traver, Chief Judge, presiding. All persons having before the court for all years give attention to me will be heard. May God save the United States of America, the state of Florida, and this honorable court. Please be seated.
Good morning. Welcome to an oral argument session of the 6th District Court of Appeal. My name is Dan Traver, and I'm joined on the panel this morning by my colleagues, the Honorable Jay Cohen and the Honorable Carrie Ann Wozniak. This argument is being streamed on YouTube, so kindly recognize that all of our statements today are being recorded for posterity. To that end, I'd respectfully ask anybody who hasn't yet silenced their cell phones to do so now. And speaking of posterity, while every oral argument before us is importance and comes with us with a great degree of significance, this one holds a special level for all of us sitting up here today, as well as Marsha Crawford. This is the very last one that Judge Cohen will participate in after a 33-year judicial career, 15 of which was devoted to the appellate bench. This is a hard thing for Judge Wozniak and I to accept because Judge Cohen has occupied a special role in both of our careers as a mentor and as a friend. I'm going to talk about Judge Cohen for a few minutes now, and the coolest thing so far about making me the chief judge is that he has to sit there quietly and accept a bunch of compliments. Neither of these situations play to his strengths. Judge Cohen has been engaged in public service for more or less his entire 45-year legal career. That started at the state attorney's office, where he served as an assistant state attorney. In 1990, Governor Bob Martinez appointed him to the county bench. In 1993, Governor Lawton Chiles named him to the circuit bench. In 2008, Governor Charlie Crist put him on the 5th District Court of Appeal, where he was the chief judge from 2017 to 2018. Over that time, he has authored over 1,000 appellate opinions. Judge Cohen had the ability, not to mention every right, to call it a career when this court was created last summer and when it began at the start of this year. His long-term colleagues had all either moved on or remained at the 5th DCA, leaving him with a bunch of people that were young enough to be his children. Judge Wozniak and I, for example, will not be answering any questions about our whereabouts in 1990. But Judge Cohen stayed because he wanted us to be successful in this endeavor, and it's much to his credit that here we are, doing business every day and serving our district. His loss will be immeasurable. I already spoke about how long he's been doing this job, and that experience cannot be replaced. But he's also had an enormous work ethic, and to that end, he cares as much about this job, I suspect, as he did on the very first day he was appointed a judge. And that's not a loss just to his colleagues, but it's a loss to everybody in this district that he serves. He has more than earned the right for this to be his last oral argument, and we all wish him the very best in the well-deserved next chapter of his life with his wife, his children, and his grandchildren. But his professional family is going to miss him very, very much. We have one case on the docket today. It is 23-1165 and 23-1306, David Wyszynski versus Rashid Shifani. Mr. Simmons, will you be doing the arguing? You may approach. You are set for 5 minutes of rebuttal time. Would you like to keep it at 5, or would you like to alter that in any way?
5 minutes for rebuttal, Your Honor.
And you may proceed.
And best wishes, Judge Cohen. And what a great loss for our judiciary. Your Honors, there are 2 main issues in this case. The first issue is the trial court's July 22, 2021 order granting the defendant's motion for partial summary judgment erroneously states on page 2 at record 5306 that the statute of limitations is 4 years, quote, meaning the claims are barred if plaintiff knew or had reason to know of Shifani/Ebrand's funding of Ladolby prior to July 8, 2012. The issue as set by the 5th District Court of Appeal in what is called Wyszynski 1, I guess, in my own phraseology, is not whether Mr. Wyszynski knew or had reason to know about the funding. It was instead whether he knew or had reason to know the funding occurred in violation of his voting rights and proper notice being given to him regarding those voting rights. When that is added to this, then, and that is what is required by the ruling by the 50 CA as to what the issue is it's not, the resounding answer to that is no. He did not know, and he did not have reason to know that his voting rights were violated. Once that's properly framed, Your Honors, the next issue is, did the trial court err when it refused to follow the federal case law and the decisions by the Florida DCAs with respect to how you address the issue of knew or had reason to know as to the accrual of a statute of limitations under the applicable standard, even after the adoption on May 1, 2021 of the federal standard. And the federal standard is defined by the 11th Circuit appeals in the case of Morton's Market. In Morton's Market, the 11th Circuit stated that it and the majority of federal courts prohibit the granting of summary judgment on whether the statute of limitations has run when the accrual of the statute of limitations is based on when the plaintiff knew or should have known when all elements of the cause of action exist. Unless the defendant can conclusively show that the plaintiff has no evidence as to the accrual or the fraudulent concealment or cause of action. And so the proper standard is not that the court is able to weigh these things. Once there has been a determination, because the statute of limitations is a defense that is an affirmative defense, the burden is on the defendant to go ahead and show that. In this case, I believe the best summary of what the evidence is in Judge Jordan's order that he entered on May the 3rd, 2022, denying the defendant's motion for attorney's fees that was filed pursuant to section 57.105.
Simmons, let me ask you this. Yeah, we know in 08, that there's a $3 million plus loan guarantee, which subordinated the 10% management fee. And then Schiavone, effectively used, the one company to pay off the debts of the other company that he was the manager for. And I'm trying to understand your argument that a reasonable person wouldn't have understood that Schiavone was using this to benefit himself.
Your Honor, the answer to that question is first, Mr. Schiavone had a high fiduciary duty to Mr. Wyszynski. Mr.
Wyszynski can't sit back and not add 2 + 2 and come up with 4 though.
That's entirely correct, Your Honor. In this case, the cover email that was sent regarding that on October 2nd, 2008, which is in the record at 2939, the cover email says, this consent was a revision to an earlier consent given in late 2007 that provided for eBrands to loan the funds directly to Ladolby. This quote cleanup, end quotes, consent was deemed necessary by the attorneys to clarify the change in the source of Ladolby funding. And then it says in the last paragraph, on a slightly different topic, the Ladolby LLC agreement will be modified to change the ownership shortly after we close the promissory note with Bunny. Bunny is Mr. Wyszynski's, who is here today, his wife. And it says, I think it will be relatively quick process, needing only your signatures on the LLC agreement. In other words, to ultimately let him be a member of Ladolby. In other words, there was this still, even as of October, this relationship where he is told that this is simply a cleanup of a prior consent that had been given, a consent that was contingent upon him being a member. Because when he was told he was not going to be a member beginning in probably February or March of 2008, it was clear that he didn't have the right to be the member, but he certainly wanted to be a member. He had the right to be told honestly the reasons that he would not be a member. That did not occur.
Understand your argument on 2008. Let's move to 2009.
All right.
Conversation with Mr. Armis about it being illegal. Does that impact what he knew or should have known?
No, it does not.
At all?
and not at all, because in 2009, what he was told was not about funding. He was told that he believed his exclusion was illegal and inequitable. The answer to that is that the defendant acknowledges that that's not a cause of action because Mr. Wyszynski did not have the right to be a member of Ladolby. But once the decision was made to not let him be a member of Ladolby, then the rules changed with respect to conflicted transactions in any transaction between eBrands and Ladolby. Because when that happened, there were consequences. And that's what the 5th DCA talked about with respect to the issue of making decisions without giving Mr. Wyszynski the opportunity to vote on them. And since he and Mr. Arias were the only two who were not members, they had literal veto power on all of that because they were non-conflicted members. Everyone else was a conflicted member. So therefore, his voting rights were denied to him, and notice of those voting rights were denied to him from the time period of about April of 2008 thereafter. And great efforts were made to keep him from knowing about that.
Okay, so 2010, after we've tried to open up a restaurant in the middle of the Great Recession, there is a bankruptcy. And your client is represented in that bankruptcy, correct?
Mr. Wyszynski was represented by counsel chosen by Mr. Chifani, and Mr. Chifani acted as the go-between in giving information relating to that.
Was Mr. Wyszynski aware that Mr. Chifani would be giving a deposition in that bankruptcy case by virtue of his independent representation?
I do not know. He didn't have independent representation. He was represented by the same counsel that Mr. Chifani was using, because Mr. Chifani used counsel for all of the investors. As a matter of fact, Mr. Wyszynski at that time went ahead along with others, and he contributed probably $50,000 or $60,000 for what Mr. Chifani was going to do was to buy eBrands out of bankruptcy. So he was certainly believing he was on the same team.
Is there anything that, you talk about the answer to the adversary position being a key point in time? Is there anything that had he wished to obtain your client before the adversary proceeding was filed that he couldn't have obtained that the bankruptcy trustee could have? In other words, if he wanted to know, is there anything that he wouldn't have been able to find out?
Oh, yes, the truth as to, because in the bankruptcy proceedings, Mr. Chifani represented in the reorganization plan, as well as the plan disclosure statement, that there were no causes of action that eBrands had against anyone to his knowledge.
Well, the bankruptcy trustee disagreed with that ultimately.
Right.
So that's my question is what, if anything, was your client prohibited from finding that the bankruptcy trustee ultimately ended up using as the factual basis of the adversary proceeding?
Well, he couldn't find out this information. He was represented. He was still relying upon Mr. Chifani. And the fact of it is that Mr. Chifani, as the CEO, the person who does the, had the great high fiduciary duty, Mr. Chifani had this duty and he was not fulfilling it. Mr. Wyszynski had no responsibility to do independent investigations. There is no responsibility of a person who is a beneficiary of a fiduciary duty to go out and double check or anything else what the person who owes the fiduciary duty says or does. Why? Because the whole concept behind being a beneficiary, such as if you are the beneficiary of a trust, you don't go out and second guess everything that the trustee is doing and scour the records to see whether or not he's telling the truth. That's one of the wrong premises that the defendant has had, is that Mr. Wyszynski had the responsibility to go out and double check everything that was being done by Mr. Chifani. The answer is no, he did not, because that would turn the concept of a fiduciary duty, in this case, particularly a high fiduciary duty, on its head.
Doesn't that contradict the knew or should have known standard for the element of constructive fraud, though? What about that should have known?
It does not, because the rule about should have known is what are the factual premises, as to why you shouldn't be out there double checking and trying to find out if the person who owes you the fiduciary duty has done something that is wrong. You don't have a duty to go check the public records. That's what the case law says. That's what the Florida case law says.
Wyszynski, though, he has a lawyer. When this deal is first proposed to him, he has a lawyer. And so he takes the documents to the lawyer, and the lawyer says, you know, hold on, you know, this is a bad deal. That Shafani is going to have complete control over everything. You're going to be marginalized. He'll have control over his own compensation in every aspect of it. And so your client's on notice as to the structure of the deal.
Your Honor, I believe that the defendant wants to say that that's what the Gray Robinson attorney told Mr. Wyszynski. There's a memo that shows that it talks about discussing the fact that the powers and the authorities and the obligation of the members to make capital calls and pay capital calls by Mr. Shafani was different than what the rules were with respect to the e-brands. And so therefore, he asked nicely, why can't we go back and do this the way e-brands, because Ladobly is supposed to be part of the e-brands family of restaurants. It was just that they were told that Disney required that it be in a separate entity, which was supposed to be held, and Mr. Wyszynski would have obtained a pro rata share of that. And so it was not to the extent that that the Gray Robinson told him that it was a bad deal. What happened is that he went to Mr. Shafani and said, this is supposed to be similar to the relationship that is in the e-brands. Mr. Shafani then, for whatever reasons, angered, or if it's in accordance with what the internal emails that were later discovered show, that he wanted to be a dictator about all of this. That's what they call him, little dictator. Is that as the dictator of all of this, he decided that he was not going to let Mr. Wyszynski be a member. That's how it happened, and that's how the emails that are explicitly show all of this, how it occurred. And so he made a request. It was denied. And so, so if we go to what the evidence is that was summarized by Judge Jordan in his order denying the defendant's motion for attorney's fees, the first thing that Judge Jordan, in summarizing what he had done, said, and this is on page 213 of the record, he says, this court, this is in paragraph 16, this court acknowledged the existence of extensive evidence supporting plaintiff's constructive fraud claims. And he says, CEG, October 25, 2021 order. Then the court goes on to say, for instance, this court therein made the following factual findings among various others. And it goes on and says, plaintiff next argues that there is a genuine issue of material fact as to whether plaintiff, and that's sick, he understands that that's really defendant, should be equitably estopped from asserting a statute of limitations affirmative defense. Said evidence is defendant's answer in the bankruptcy case that occurred in 2012 to 2013. Defendant's emails detailing the reasons for excluding plaintiff from Ladobly.
You're into your rebuttal.
Was
I don't know if you want to keep anything else. There's a cross appeal.
2 minutes.
Okay.
Then I'll extend my. All of these items here are factual evidence that the court ultimately said, and here's what he says on paragraph 18. Thus, this court already expressly determined that plaintiff proffered evidence establishing the factual merit of his constructive fraud claims. That includes, Your Honor, that includes all of this list of things in paragraph 17 that show not only equitable estoppel, but because of the time of the duration, some of them in 2008, 2009, all of these show that it is a basis for fraudulent concealment. So he used the word equitable estoppel, but the result of it is that there is ample evidence that there could never have been any kind of weighing of the statute of limitations or excuse me, weighing of the evidence, that under Morton Market, the court cannot, absolutely cannot weigh the evidence. And that is similar to what Your Honor has already said in the case, Judge Traver, what you did, talking about the case of Lancheros versus Burke, using the standard for granting a directed verdict, which is similar to what someone would apply in a case of a granting or denial of a motion for summary judgment, as well as what was recently determined in the Reyes case, Reyes versus Baptist Health, which is a 2023 case in which the third DCA said Florida courts have held that this determination of when a person knew or reasonably should have known of the possibility of medical malpractice, it doesn't make any difference if medical malpractice or anything else, is fact specific and within the province of the jury, not the trial judge. And so, Your Honor, we would request that there be a reversal, a remand, so that the jury can actually address this issue of when Mr. Wyszynski knew or had reason to know as to whether the funding violated his voting rights. Thank you.
Morning, Mr. Santuri. Good morning, Your Honors. You have a cross appeal. Would you like to reserve any time for rebuttal?
Yes, sir. If I could reserve 3 minutes.
May proceed.
May it please report, and congratulations, Judge Cohen, on your retirement, and thanks for the service over all of these years. It sounds like the panel has a pretty good handle on the main issues on appeal, and I'm happy to address any questions on it. I'd actually kind of like to jump to the cross appeal, but before I do that, I do want to touch on one thing that Mr. Simmons was focused on at the end, and part of the reason I do this is because it's happened, seems to happen multiple times, is that the court issues an order that recites the arguments of both sides, and Mr. Simmons tries to adopt that as a factual finding. And even here in the section he read, he recited that it begins with the plaintiff argues that there's evidence of these things, and these are the things that plaintiff claims are evidence. That's not a finding of the court, as I understand it. That's simply the court acknowledging that these are the arguments made by the plaintiff. And I think it's important to recognize that the section that Mr. Simmons is citing to was not part of the MSJ ruling at all. In fact, in the MSJ ruling, the court was very specific. He said statute of limitations applied, and the plaintiff offered no evidence of equitable estoppel or any other tolling of the statutes. Zero evidence. Even today, they still can't identify any evidence that the statute of limitations should have been told.
Was Judge Jordan right when he found that equitable estoppel had to be led as a separate cause of action panel of some sort?
Your Honor, I have tried to understand that ruling, and I know we covered it quite a bit in the brief. I think there are two issues there. So I think there's a question of whether there's equitable estoppel as to the statute of limitations. But if you look back at Judge Jordan's order, that's in the context of the motion for reconsideration. And what he was addressing there was the fact that plaintiff had cited case law that talked about a whole variety of different types of estoppel. They talked about judicial estoppel, collateral estoppel, equitable estoppel as to affirmative defenses, and other types of equitable estoppel. So in the context of the motion for reconsideration, my understanding of Judge Jordan's order was, with respect to equitable estoppel on the statute of limitations, there is no evidence of it. To the extent that you claim that there are other theories you have, other equitable estoppel theories that you have, that hasn't been pled adequately, and you haven't presented it in the context of summary judgment. That was how I understood his order.
And here's how I understand what you just said, which is that Judge Jordan was wrong about that, but that it's harmless.
Yes, Your Honor, I do believe it's harmless. I don't know that he was necessarily wrong. I just think that he was trying to address.
Well, either he's wrong or he's right. Can't have it both ways.
Well, I don't think he was wrong. And maybe I'm not explaining it very well. I think that what Judge Jordan was doing was sort of ticking off all the boxes with respect to equitable estoppel as it pertained to statute of limitations. There was no
I don't
evidence.
think equitable estoppel has to be blood as some sort of cause.
I think that there is a cause of action for equitable estoppel, and I think it was unclear what the plaintiff meant when it was trying to argue that there were other causes of action and other. So remember, this was in the context of after he granted summary judgment, he gave the plaintiff the opportunity to identify any other cause of action they might have. And amongst all of the things they said, they referenced equitable estoppel and they cited case law that was all over the map, all different types of estoppel. And so I think Judge Jordan was essentially going through and identifying, these are all the things you've told me are the basis to continue this case. And none of them change my opinion as to whether the statute of limitations precludes the cause of action you presented in here. But to the extent that he is wrong, yes, I don't think it's harmless because we have. You don't think it's harmless? All right, I think it's harmless error because we have briefed this. He has covered all of the evidence with respect to estoppel. They have had countless opportunities to offer evidence of it, and they have yet to offer any evidence of estoppel. It really goes back to, and we cite Justice Cantero's explanation of equitable estoppel as it relates to the statute of limitations, where he talks about how the parties acknowledge that there is a claim and that the defendant makes statements to try to convince the plaintiff not to bring those claims. That's the type of equitable estoppel that applies to statute of limitations. Here, plaintiff has never acknowledged that there was a claim until they filed suit, and they can't point to any evidence that Mr. Trapani ever made any statement or that Mr. Wyshynski relied upon any statement to delay bringing his claim. In terms of the cross appeal, from our perspective, this case in my mind is sort of really is the model answer for where you would award 57-105 fees.
Let me just ask you generally, I think it's probably fair to characterize this case as fact intensive.
Yes, sir.
Is the position necessarily, if we agree with that aspect of your cross appeal, that any case that is barred by the statute of limitations that didn't have factual support is automatically sanctioned?
I think that's what the statute says. The statute says that the court shall award fees where there are not material facts.
But I wonder, and I'll tell you, I think where I'm struggling with this a little bit is the notion that this was such a factually intense sort of situation. And I think that you have to concede that the standards between when summary judgment is entered and when a case is declared frivolous for the imposition of 57-105 sanctions is different. Correct?
Yes, Your Honor.
So one's higher than the other by necessity, or otherwise you'd have prevailing party fees on every summary judgment case. So if we start with that particular proposition, do we always have a situation then, even if it's filed a day late, for perhaps a justifiable reason, that it then mandates, if you win on a statute of limitations affirmative defense, that sanctions must therefore be entered? Can you answer that question without talking about the facts of this case?
I think that's, I don't think so. I think you have to look at the facts. And I think the statute allows for that because it talks about whether it's supported by material facts. So it's not just any fact you could throw out there. It's not some irrelevant facts. It's not background noise. It's whether there are material facts that support their position. And from our perspective here, I don't know that we don't necessarily need to reach I don't think the court needs to reach the question of, if there's ever a time where you can't identify a fact, you shall award fees. I think here in this case, Your Honor's right, it is a fact intensive case, but this is a case, at least with respect to 57-105, where that mountain of facts are all in favor of statute of limitations from my perspective. I mean, we submitted back in 2017, we provided them with, this wasn't just a flippant email of, we're going to seek 57-105 on you. This was a detailed motion with 1,500 pages of support. Here are all of the reasons, here are all of the claims you had set forth in your complaint. And here are all of the times that Mr. Waschinsky knew about these facts and chose not to move forward. That was presented in 2017. He's deposed, he's asked about these same facts, and he acknowledges, yes, I got these emails. Yes, I knew about this. Yes, I was receiving financial statements. Yes, I had a lawyer who looked at this. You know, he had a lawyer who not only looked at the formation of Ladolve and explained to him, if he didn't understand before, all of the money that was going to be, all of it was going to be funded by eBrands. She also made reference to the voting rights and the fact that the voting rights were very different between Ladolve and eBrands. So he had not only information on his own, he had financial advisors, he had multiple lawyers helping him not only with respect to that Ladolve transaction, but also with corporate governance in general, where he had lawyers seeking documents on his behalf. We had all of that information, and to date, they've never offered any factual evidence in the record, as recognized by Judge Jordan, and even here today, there's nothing that supports the notion that in fact the statute of limitations didn't apply. I just don't know what more a party would need to show in order to get 57-105 fees than what we had in this case.
Is there an analogous case that's fact intensive like this one, where the trial court denied fees and then the appellate court reversed and awarded all fees?
Not that I'm aware of, no, Your Honor. There is a case,
I know there was one cited.
yes, Your Honor, the Shuck versus Smalls case. And that was a case that I think is particularly relevant for our purposes, not only with statute of limitations. That was an instance where the trial court had initially awarded 57-105 fees as of the time of the motion for summary judgment. Essentially, by the time you had summary judgment filed, you should have known.
But that was a
awarded
point in
fees.
time. So the
Right.
appellate court reversed and said, no, you're going to get more fees. But
Right.
is there a case where no fees were awarded?
I don't remember looking for that, Your Honor, no.
It's a tough standard. I understand that you're arguing that the standard should be different because you're saying that the lower court made a legal error by looking at the claim as opposed to the defense. I get that. But it would seem to me that even if that's correct, that the standard would still be abuse of discretion at the way that we look at the record.
So I'm not sure I agree with that, Your Honor. I mean, I do think that the law, as it in that Shuck versus Smalls case, talks about the question is not whether they were able to successfully allege facts to support their claims. It's whether they had any facts, whether they had facts supporting their avoidance of the affirmative defenses. And that was exactly why that point in time changed in that Shuck case, was that, you know, it wasn't at the time of summary judgment that this became a frivolous case. It was the fact that when presented with that, with the argument on statute of limitations, you didn't have any facts that would have supported avoiding the statute of limitations. And here, I think that the Judge Jordan made a mistake, a legal mistake in terms of the way he analyzed. If you take a look at his order, and I will say that his order is identical to the letter from the proposed order that defendants offered him in terms of denying our motion. But if you take a look at his order, paragraph 8, he references the 5th DCA finding it was a cause of action. Paragraphs 10 and 11, the 5th DCA already found there's a cause of action. Paragraph 12 and 13, you stated a cause of action for constructive fraud. Paragraph 14, 5th DCA, 16 and 17, extensive evidence of constructive fraud. And then 17, he restates the allegations, and in 18 and 19, he says you had a basis for constructive fraud. That's not the test. The test is, did you have a basis to avoid statute of limitations? He never once in his order references any.
And maybe we lost each other in my question, because I don't necessarily know that that's false. Maybe it is. Maybe Mr. Simmons will tell me something to make me change my mind on that. But it would appear to me that just because he applied that incorrectly doesn't mean that that changes our standard of review.
Well,
Unless you're asking us to remand for consideration under because you considered the wrong legal issue, which is not how I read the prosecutor.
no, Your Honor, and we cited the law in our brief. I can pull it up, but I mean, if he made an error of law, it's de novo review. So, and I think that was specific to the statute of limitations. I can check my brief.
But if he made an error of law on something where otherwise his review on coming up to us would be on an abuse of discretion, wouldn't then the remedy to be to say, hey, judge, we know you did your best like you always do, but you applied the wrong test. So go back and apply the right test and then let it come back up to us again.
So
As opposed to saying two things. Number one, you apply the wrong test. And two, by the way, we've looked at that whole record by ourselves because it's, easy to digest. And we'll, as a result, we're just going to say sanctions.
And I think that is absolutely the right path here, is that he did apply the wrong law, and you can find that, but I think that you can also look at this in terms of an abuse of discretion. You can find that, his own order found that there was zero evidence supporting the avoidance of the statute of limitations defense. That was his finding, and ultimately he has never found otherwise.
Yeah, that's what I was driving at.
Right.
Is that I don't think that it's appropriate to say that it's an over review for the relief that you're requesting.
Right, Your Honor. I think that in terms of finding that we should have been awarded back my client should have been awarded 57,105 fees. I do think you look at that as abuse of discretion, and I think that we have met that with the record that we have. There is one other minor issue on the cross appeal, and that's just if the court reverses on the statute of limitations. There was one other motion for summary judgment that related to whether the court had to enforce the 5th DCA's mandate. Unless the court has any questions for me on that, I'll just leave the rest of my time for rebuttal.
Thank you.
Thank you.
I want to ask a question, just generally speaking, about the applicability of 57,105 to a statute of limitations defense where a high level, and let's assume the very highest possible level of fiduciary duty, whether that's pre-penitent, or whatever happens. Can it still be sanctionable? And I'm not asking you to talk about your case. I'm asking you to talk about a point of law.
Based upon the case law that that we cited in our brief, and that is that when you are the beneficiary of a high fiduciary duty, you don't have a duty to be out there checking around. But if in fact, clear revocation or rejection of the fiduciary relationship is such that you are then put on notice, then you have the duty to go out and check. But only after there has been a literal rejection, something that is obvious, that will put you on notice that the person who owes you the fiduciary duty has in fact taken action against you. And that's what the case law says. And so, yes, it could be done if it's only after there has been something that would put you on clear notice that there has been a rejection by or some wrongdoing by the person who owes the fiduciary duty to the person who is owed the fiduciary duty. And Your Honor, with respect to the assertions about what Judge Jordan has determined, Judge Jordan clearly said that that there was the existence of extensive evidence supporting the plaintiff's constructive fraud claims. This is in paragraph 16 on record page 10-13. And then in paragraph 17, the court then says,
That's true. If there is extensive support for the underlying claim, but the defense is overwhelming and any opposition to the defense is frivolous. And again, I know you dispute that, but just as a matter of law, are you saying that just because a claim has merit, that a defense can never be the basis for 57,105?
No, Your Honor. What I am saying is that the judge went ahead and recited 6 different issues that show where there was a ground for what he called equitable estoppel. It's also the same thing as, if it's before the statute is run, it's the same thing as a fraudulent concealment or something that delays the actual accrual of the cause of action. He recites those things, and he says that this court therein made the following findings among the various ones. And then a court says, thus, this court already expressly determined that plaintiff proffered evidence establishing the factual merit of the constructive fraud claims. And within those constructive fraud claims, as much as the defendant doesn't want to admit it,
You could just
Are
wrap up,
these-
Mr. Simmons?
yes,
No, if you can just wrap up, you can
Okay.
finish your thought, but you're just well into you're well past your time.
Yeah, sure. He determined that these actually do exist. These facts do exist. They were proffered and they are grounds for the granting of in this case, first, the denial of any request for attorney's fees. But secondly, it is under the Morton's market case. It's not for the court to be determining. It is something that should be left to the jury to determine. Thank you, Your Honor. And again, thank you and best wishes.
Thank you, Mr. Simmons.
Mr. Santuri, if you'd like, you'll have an extra minute 20 on top of the 5:14 that you already have. Go ahead.
Thank you, Your Honor. I do want to come back and just sort of hit again on, or make sure that I was clear on the question you asked me. And that was, I think that, yes, this case is fact intensive. But the facts haven't changed since 2007, 8, 9. And they haven't had, the other side hasn't come up with a single fact that trumps the statute of limitations, not a single fact to avoid the statute of limitations. And I think that really says it all. I think that, not only did we have the facts, but Mr. Wyszynski was deposed and he didn't deny any of those facts, then he was never offered any testimony in the context of summary judgment to deny that any of these facts or to offer any testimony that supported any sort of avoidance of the statute of limitations. So, I think that given the language of the statute that says that where there's no material fact supporting it, you shall award fees. I think that that's what should have been done. And I think this court can do that as part of its order.
So would an opinion then have to be extraordinarily long in terms of talking about time frame and supporting evidence, akin to the timeline and information that was handed the first 57-105 motion? Or is it a really short opinion that basically says no defenses equals 57-105 because the statute says shall?
I don't think it has to be a long opinion, no, Your Honor. I think that there are several key facts that were known back at the time of 57-105, and these same facts were relied upon by the court to grant summary judgment. And at no period of time during summary judgment or since did the defendant ever come with identify any material fact in the record to support avoidance, and that is sufficient for 57-105, and the court shall award fees based upon that. If you all don't have any other questions for me, I'll sit down.
All right. Well, thank you very much. Thank you both for your presentation. And we'll be in recess.